Order now settled, ready for this hearing. I will therefore allow the clerk to call the first order. Proceed, clerk.
Order number 2, Deputy President of the Republic of Kenya.
Honorable Senators, ladies and gentlemen, having dispensed with the pre-hearing meeting of the senators, which was a closed session, it is now time to commence the proceedings on the proposed removal from office by the people of His Excellency Gachagua. Letter reference number AA/BLQ/TDO/MTS/20 to the National Assembly inform the Speaker of the Senate that at the sitting of the National Assembly held on Tuesday, the 8th of October 2024, pursuant to Article 145(2), as read in Article 150 of the Constitution, the National Assembly approved a motion for the removal from office by impeachment of His Excellency, being the record of proceedings in the National Assembly and the evidence produced in support of the impeachment motion. 1. A copy of the notice of special motion in the 6th of September 2024 and received on the 27th of September 2024, running from page 40 to 42. 2. Electronic evidence related to the special motion contained in the flash disk. 3. For the papers of the 1st of October 2024, communication from the Chair, number 047 of 2024, issued on Tuesday, the 1st of October 2024. Certified answer and votes are proceeding for the 1st of October 2024. Communication from the Chair, number 048 of 2024, issued on the 2nd of October 2024. Letters of appointment of advocates for A. Swain and Company Advocates for His Excellency the Deputy President, B. House President, forwarding the notice of motion. Affidavit of service from His Excellency the Deputy President. Order paper for the 2nd of October 2024. Certified answers and votes and proceedings for the 2nd of October 2024. Public participation advertisement of the 2nd of October 2024, being the Daily Nation newspaper, Standard newspaper, Star newspaper, and Taifa Leo. Public views, 10/8, English and Kiswahili. Memo to constituency/county office managers, dated the 4th of October 2024. Public participation advertisement of 4th of October 2024, being Daily Nation newspaper, Standard newspaper, and Star newspaper. Order issued by the High Court, sitting at Kerugoya on Friday, the 4th of October 2024. Press statement by the clerk of the National Assembly on extension of public participation issued on the 4th of October 2024. This communication is long, and the bearing the situation of Senator Gloria Roba, I will allow her to take a seat. Praise statement by the Clerk of the National Public Participation Advertisement of the 5th of October 2024, based standard Saturday Nation newspaper and Standard newspaper. Public participation report tabled on the 8th of October 2024, response to the notice of special motion from His Excellency the Deputy President received on the 8th of October 2024 at 4 p.m. Electronic evidence by His Excellency the Deputy President relating to the special motion from the Chair, number 049 of 2024, issued on Tuesday the 8th of October 2024, and certified answer and votes and proceedings for the 8th of October 2024. Now, Honourable Senators, pursuant to Article 145, subsection 3A of the Constitution, the charges against His Excellency the Deputy President, as contained in the motion of impeachment by the National Assembly, were read out to the assembled Senate. Honourable Senators, at this juncture, allow me to remind you of the mandate of the Senate in relation to the proposed removal from office by impeachment of the Deputy President, together with standing with us at the aid of the Senate. In particular, Article 150 of the Constitution states as follows: the Deputy President may be removed from office, A, on the ground of physical or mental incapacity to perform the functions of the office, or B, on impeachment on the ground of a gross violation of a provision of this Constitution or any other law, and 2, gross misconduct. 2, the provisions of Articles 144 and 145 related to the removal of the Deputy President. Now, Article 145 of the Constitution, standing orders 78, Part 1, the Secretary of the Standing Orders opposed removal of office, standing orders 78(1) of the Senate, provided the Senate may, by resolution, appoint a special committee comprising 11 of its members to investigate the matter. Honourable Senators report that at the sitting of the Senate, held on Wednesday the 9th of October 2024, the motion for establishment of a special committee for the investigation on the proposed removal from office by impeachment of His Excellency the Deputy President of the Republic of Kenya to be held in later. Honourable Senator Karen, attention. By way of status update, pursuant to Rules 4A and 6 of the Rules of Procedure, when considering the proposed removal of the Deputy President, in plenary, the Senate invited the Deputy President to appear and be represented before the Senate during its investigation. The Senate further invited the Deputy President, if he so chooses to appear before the Senate, to file an answer to the charges with the Office of the Clerk of the Senate by 5 p.m. on Monday, 15th of October 2020. 2. The mode of appearance before the Senate, whether in person, by advocate, or in person and by advocate. 3. The names and addresses of the persons to be called as witnesses, presented as such witnesses before the of the Rules of Procedure when considering the proposed removal of the Deputy President plenary. The Senate notified the National Assembly of the date for the commencement of the investigation and invited the National Assembly before the Senate during the investigation. The National Assembly was further invited, if he so chooses, to appear before the Senate, to file with the Office of the Clerk of the Senate by 5 p.m. on Monday, 15th of October 2024, setting out documentation before the Senate. 2. Indicating the mode of appearance before the Senate, whether in person, by advocate, or in person and by advocate. 3. Indicating the names and addresses of evidence to be presented by such witnesses. Ladies and gentlemen, 14th of October 2024, the Office of the Clerk of the Senate received a response reference number SW/PET/153/VOEN/01/2024 and dated the 14th of October 2024 to the invitation to appear issued to the Deputy President to represent him in the proceeding before. The letter also indicated the list of counsel representing His Excellency, the Deputy President, and the list of witnesses for the Deputy President. Similarly, on 14th of October, CAN post on 2024 into bracket 562 and dated 14th of October 2024 have been appointed to represent the National Assembly and that the National Assembly will appear in person and by advocates. The letter also indicated the members of the National Assembly representing the National Assembly in these proceedings and the witnesses of the National Assembly. Good procedure when considering the proposed mover from office of the Deputy President in plenary on Monday, 14th of October 2026 at 7 of the rules of procedure. Honorable Senators, ladies and gentlemen, the hearing program, which has been presented to today's order and determination of the matter and the time allocated for each activity, it will comply with the time allocated. The parties will be notified of the balance of time in each activity through the clerk's other table. The charges against the Deputy President, as submitted by the National Assembly, shall be read. Thereafter, His Excellency the Deputy President will be given an opportunity to take a plea on the charges. This will be followed by an opening statement by the National Assembly and the Deputy President. After the conclusion of the opening statement, the presentation of the case to the National Assembly shall commence. The National Assembly will have a maximum of 3 hours for presentation of the case and examination, while the Deputy President will be allocated 2 hours for cross-examination of witnesses after presentation of the case by the National Assembly. Honorable Senators will be given an opportunity to ask questions or seek clarification from the National Assembly. This will take us up to the end of today's sitting. The sitting scheduled for tomorrow, Thursday the 17th of October 2024, His Excellency the Deputy President will present his case before the Senate. The Deputy Assembly will be allowed 2 hours for cross-examination of witnesses. Honorable Senators will also be given an opportunity to ask questions or seek clarifications from the Deputy President for 1 hour each. As provided, after the closing statements have been made, the hearing shall conclude and the Senate shall proceed into camera session to deliberate on issues raised. The Senate shall thereafter proceed to read a special motion prior to voting on each of the charges. At this stage, a supplementary order paper will be issued to facilitate the proceedings. In accordance with Article 1.57 of the Constitution and standing of the 78 of the Senators, if at least 2/3 result in the removal of the Deputy President, the Speaker of the Senate shall notify the Speaker of the National Assembly accordingly. Honorable Senators and the members representing the National Assembly,
Mr. Speaker, sir, for the National Assembly, the legal representation is as follows. The Honorable James Orengo, Senior Counsel, leading the team. Mr. Paul Nemoi, Legal Counsel. Myself, Eric Gumbo, Legal Counsel. Mr. Moses Kipogei, Legal Counsel. Mr. Peter Wanyama, Legal Counsel. Mr. Speaker, sir, our young colleagues, Mr. Alex Bayer, Legal Counsel. Mr. Elias Oma, Legal Counsel. Mr. Eric Muriuki, Legal Counsel. Mr. Boniface Mawira, Legal Counsel. And Ms. We have the Honorable Ochete Amolo, Senior Counsel. We have the Honorable John Itonga Bugara. We have the Honorable Samuel Chekonga. We have the Honorable John Makali. And we also have the Honorable Zamzam Mohammed. I submit, Mr. Speaker.
Similarly now, the Vice Counsel to His Excellency Gachagua, DPH, the Deputy President of the Republic of Kenya, to introduce the legal team representing His Excellency the Deputy President by stating the full name and definition of each person. Counsel, you may proceed.
Honorable Senators, the legal team representing His Excellency the Deputy President of the Republic are as follows. Myself, Paul Muite, Elisha Ongoya, Tom Macharia, Swanya Victor Ogeto, Ndego Amos Kisila Kiba, Andrew Muge, Eric Naibei, Mrs. Julia Omwamba, and Mr. We will be raising an issue about one of the members of the legal team.
On behalf of the Senate, I welcome the National Assembly and his team, His Excellency Gachagua, PGS, the Deputy President of the party. Now, as you are aware, Article 118 of the Constitution mandates Parliament to conduct its business in an open manner, and that its sittings and those of its committees shall be open to the public. The hearing of the proposed removal from office for the 78th and the second sitting to the standing orders of the Senate is a matter that has generated immense public interest. The Senate, in this particular hearing, has facilitated members of the members of Parliament, which state as follows. Visitors in the gallery shall remain seated, shall not allow, comment only, make signs, eat, sleep, read, or create any disturbance. And the Speaker's work of the Senate is directed to ensure compliance with the Speaker's rules. Honourable Senators, ladies and gentlemen, finally, I now the Parliament. Yours.
Mr. Speaker, sir, my name is Degwanjiro, and Paul Muite did raise an issue that we have an objection in terms of the appearances. Objection is in line with the conduct of this House, and the records bears as witness that we also have, we'll also be relying on an authority in our objection. Mr. Speaker, sir, we are raising an objection to the appearance of the National Assembly in these proceedings. And this is the basis of our objection briefly, that my learned friend, Senior James Orengo, is a full-time serving state officer as per Article 260, subsection 2 of the Leadership and Integrity Act, which bars a full-time state officer from engaging in meaningful employment. Mr. Speaker, sir, it will be prejudicial to our client if this House was to allow these proceedings. Mr. Speaker, sir, just recently, this House, which is a House of record, we bear as witness that during the impeachment of the Deputy Governor of Kisii County, the County Assembly attempted to appear raised by my learned friend, Senator Chargay, which objection was sustained by this House decision, that is 04 of 2019, where Justice Ogola barred his error of Kenya Port Authority, one Daniel Maduk. The judgment is before not then purport to appear and represent a party before this assembly. It will raise serious conflict in violation of clear provisions. Speaker, sir, we invite you to uphold our objection before the charges are read out to the to our client. Mr. Speaker, sir, in this ruling that I've just cited, engagement as a state officer cannot and is barred from representing a party in a private capacity. We so beseech you, Mr. Speaker, sir, to uphold our objection. I am most humble.
If you look at our progress, the preliminary objections were to be raised after His Excellency has taken leave. And therefore, we'll allow the clerk to read the charges before anything else to respond, and thereafter I will make a ruling, and then we'll take it through.
I am most obliged, Mr. Speaker, sir.
Proposed removal from office by impeachment of His Excellency Gachagua, EPH, Deputy President of the Republic of Kenya. Particulars of the applications. Your Excellency Gachagua, EPH, Deputy President of the Republic of Kenya. Please take the stand. Your Excellency Gachagua, EPH, Deputy President of the Republic of Kenya. The grounds for your proposed removal from office by impeachment, as received by the Senate from the National Assembly, are as follows. But A, 51B1 of the Constitution, from 73(1)A and 2B, 75(1)C, and 129(2) of the 2C and D of the Constitution. The preamble of the Constitution provides, among other things, the land and determination to live in peace and unity as one indivisible sovereign nation, and B, recognizing the aspirations of all Kenyans for a government based on the essential values of human rights, equality, freedom, democracy, social justice, and the rule of law. The preamble of the Constitution establishes the core national values and principles. These values and principles are justice, inclusiveness, non-discrimination, equality, human rights, protection of the marginalized, democracy, and establish responsibilities of leadership. They provide that the authority assigned to a state officer, such as the Deputy President, is a public trust to be exercised, demonstrates respect for the people, brings honor to the nation and dignity to the office, and promotes public confidence in the integrity of the office. Also, Article 27(4) of the Constitution prohibits all forms of discrimination, including birth. Further, objective and impartial, and should not be influenced by favoritism and improper motives. Furthermore, Article 75(1)C of the Constitution provides that a state officer should behave, whether in public and official life, in private life, or in association with other persons. As a matter of constitutional compliance, the Deputy President of the Republic of Kenya, who is the principal assistant to the President of the Republic, is required: A, ethnic, cultural, and religious diversity, patriotism, national unity, rule of law, democracy, and non-discrimination, and protection of the marginalized and good governance. B, to respect and affording equal opportunities to all Kenyans in appointments to the public service and allocation of public resources against any Kenyan. However, regarding Gachagua has persistently made utterances threatening to discriminate, exclude, and unlawfully deny sections of the people of Kenya and regions of the Republic of Kenya equal opportunities for public service appointments and allocation of public resources, and insightful and diverse communities. To illustrate, A, sometime in 2023, at a public forum and insightful public pronouncements to the effect that the government of Kenya is a company, and that the allocation of government development projects and public sector jobs are based on shares determined by how the populace of the various ethnic communities. Quote, the government is like a company. There is shareholding. Kuna wale who have invested a lot of shares, kuna wale wameweka kidogo, kuna wale wamekataa, lakini wote ni Wakenya. So ndio tukasema kama wewe umeenda kupanda mahindi, ama wacha nipeane example ya ng'ombe, kwa sababu niko Kajiado. Wewe umeichunga vizuri, umepatia chumvi, umepeleka kwa malisho, umepatia maji, imezaa, imeanza kukamuliwa, wewe maziwa. End of quote. His Excellency Gachagua emphasized ambaye alikuwa sema hii ng'ombe maziwa, hii ng'ombe hata ikipona jicho moja, wachana nayo, unapoteza wakati. Saa ile ng'ombe imezaa, anataka atolewe maziwa. Mimi nikasema hiyo haiwezekani. Nikasema yule mwenye hii ng'ombe ile itabaki aitie majirani. Hata yule alikuwa anapiga kelele akisema hii ng'ombe ni bure na haiwezekani na hiyo. End of quote. His Excellency Gachagua made similar remarks at another public forum as follows. Quote, a government is like a company. In every company, there are shares. Preferential shares and ordinary shares. When there is an AGM, non-shareholders do not vote or attend the AGM. When there are dividends, Vice Gachagua continued the insightful and ni kampuni na ni ya shares. Sindio? Ni ya shares. Kuna wenye kampuni, hii kampuni ya William Ruto na Rigathi Gachagua. Sasa lazima mvune. Yule ambaye alipanda atafanya nini? Simulipanda. Simuliamka mapema. End of quote. At another narrative as follows. Quote, Raisa ako pale niko hapo. Raisa ako pale niko hapo. Huyu Felix ako hapo. Mimi nanijua msimamo wangu ya kwamba watoto wakiwa wengi, kuna wale kwanza ya kuangaliwa. Sinajua. Sasa huyu Felix ako pale ndiye kuunganisha mawaya. Mambo yenu tumepanga. Mambo iko sawa. Chakula iko jikoni, karibu kuiva. Watoto ni wengi, chakula ni kidogo. Iko watoto na nyinyi utulie. Chakula ikiiva, sisi ndio wenye kupakua. Na watoto tunawajua kwa sura na kwa msimamo. Hatuwezi kuwa confused. Kuna mtu hajui watoto wake. Na wiki inakuja tutazame tofauti. In addition, in September, public utterances that incited other by stating as follows. Quote, na mimi mkaniambia nimsaidie rais kwa kazi. Lakini nikiwa hapo kwa serikali, nikuwe pia nikichunga mambo ya watu wa mlima. Niendelee kuchunga mambo ya mlima, ambiwa mimi ni mkabila. Mimi ni mkabila kweli? Nikichunga mambo ya watu wa mlima, iko makosa? Iko makosa? End of quote. His Excellency Rigathi Gachagua's utterances throughout the country.
Clerk, just pause for a minute. Honorable Senators, just put your phones on silence.
His Excellency Rigathi Gachagua's utterances throughout the past 2 years. In addition, they have the potential to alienate, isolate, and create disharmony among the various ethnic communities of Kenya. In summary, to the extent that they grossly violate Articles 10, 2A, B, and C, 27.4, 73, 1A, and 2B, 75, 1C, and 129.2 of the Constitution, and that specifically, His Excellency Rigathi Gachagua's divisive and insightful public utterances over the last 3 years, A, are incompatible with the high calling and can stir ethnic, falsely alluded to an existent government policy to discriminate and marginalize the populace of the regions and tribes that do not vote for the current administration in the 2022
guilty.
Ground 2, Article 147(1) of the Constitution provides that the Deputy President shall be the principal assistant of the President and shall deputize for the President in the execution of the President's functions. In addition, Article 152(1) of the Constitution states that the Deputy President is a member of the Cabinet. On various days throughout the last 2 years, His Excellency began his executive mandate by making unilateral public statements that were inconsistent with policy positions collectively adopted by the government. To illustrate, the Cabinet passed a resolution for the evacuation act. His Excellency Gachagua made a public statement opposing the Nairobi River riparian evacuation orders. Gachagua made contradictory public statements despite being a member of the Cabinet and being assigned the function of several occasions throughout the last 2 years, made public statements contradicting the President on critical matters of governance and the exercise of the President's functions as a symbol of national unity. To illustrate, in March 2023, at a public forum in the Nyanza region, the President said Kenya belongs to all, but the government does not discriminate against anyone. However, contradicted him by saying that Kenya is a company in which the provision of government services is based on shares. Being that he publicly states determined by how various ethnic communities voted in the 2022 general elections. His Excellency Gachagua's unilateral extent that A, they undermine the effective discharge of the national government's executive mandate. B, they violate the doctrine of collective responsibility, constitutional status as a principal assistant to the President of the Republic of Kenya. Your Excellency, regarding Gachagua, how do you plead to Ground 2, guilty or not guilty?
Not guilty.
Ground 3, gross violation of Article 6(2) to the Constitution, that is, undermining devolution. Article 10(2)(a) of the Constitution provides that devolution is a fundamental national right, that governments at the county and national levels are distinct and interdependent and shall conduct their mutual relations based on consultation and cooperation. These provisions are supplemented by Article 189(1) of the Constitution, which provides the integrity of government at the other level. Under paragraph 7(a) of Part 2 of the 4th schedule to the moreover, the Deputy President chairs the Intergovernmental Budget and Economic Council, an essential organ for consultation between the two levels of government. On or around 20th September 2024, His Excellency Rigathi Gachagua recklessly and mindfully interfered with the running of Nairobi City County government by holding a public rally in which he incited citizens against lawful directives of the Nairobi. His Excellency Rigathi Gachagua publicly discovered His Excellency Rigathi Gachagua regarding alcohol control and regulation. His Excellency Rigathi Gachagua's insightful and demeaning public statements and conduct they undercut the functional and institutional integrity of county governments. C, they unjustifiably vilify and ridicule. Consequently, His Excellency Rigathi Gachagua has grossly violated Article 6(2).
Clerk, just a minute. I realize what you're reading was fairly low. His Excellency the Deputy President, if you may sit, and when taking the plea, you may stand.
No, Mr. Speaker, let me stand.
You may proceed, Clerk.
Repeat. Consequently, His Excellency Rigathi Gachagua has grossly violated Articles 6(2), 10 to the Constitution. Your Excellency Rigathi Gachagua, how do you plead to Ground 3, guilty or not guilty?
Not guilty.
Ground 4, gross violation of Article 161 of the Constitution, that is, undermining the Constitution, provides that the judiciary shall be subject only to this Constitution and the law, and shall not be subject to the control or direction of any person or authority. The judiciary's independence and require all government officers and institutions to respect and observe it. In 2023, His Excellency Rigathi Gachagua, recklessly, unmindful of the high calling and dignified status of the office of the Deputy President of the Republic of Kenya, and the need to respect, protect, and uphold the independence of the judiciary, made a scathing public attack against the Honorable Lady Justice S. petition for the removal of the said judge. The Honorable Judge had presided over a case in which His Excellency Rigathi Gachagua was a party and had, in the lawful performance of my judicial functions, ordered His Excellency Rigathi Gachagua forfeit to the state the sum of Kenya shillings 200 million, which she had found to be proceeds of corruption and money laundering. His Excellency Rigathi Gachagua's public attacks against the judge and additional independence of judges. Your Excellency Rigathi Gachagua, how do you plead to ground 4, guilty or not guilty constitution, that is breach of the all utterances outlined in grounds 1 to the Constitution, which requires every person to respect the Rigathi Gachagua, grossly violate Article 148(5)(a) of the Constitution, which prescribes the oath of allegiance of the office and defend the Constitution and all other laws. Your Excellency Rigathi Gachagua, how do you plead to ground 5, guilty or not guilty?
Not guilty.
Part B, serious reasons to believe that the Deputy President has committed a crime under national law. Ground 6, serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under Section 13 Integration Act. Section 13 of the National Cohesion and Integration Act provides that it is an offense for any person to use threatening, abusive, hatred, hostility, violence, or discrimination. The section also makes it an offense to use such words or engage in such behavior when having regard to all the Section 62 of the National Cohesion and Integration Act states that a person commits an offense when the person makes statements that are intended or are likely to mention. His Excellency Rigathi Gachagua's persistent, inflammatory, reckless, insightful public utterances over the last 2 years, the details of which are set out committed crimes under Section 13(1). Say Rigathi Gachagua, how do you plead to ground 6, guilty or not guilty?
Not guilty.
6, 47(a)(3) and 48(1) of the Anti-Corruption and Economic Crimes Act and Sections 2. His Excellency Rigathi Gachagua has inexplicably amassed a humongous properties of corruption and money laundering. The value of the property and wealth that His Excellency Rigathi Gachagua has acquired over the last 2 years is incompatible with his non-legitimate income, that is, Kenya shillings 12 million per annum or thereabouts. His Excellency Kevin Rigathi Gachagua, Keith Ikino, and other close family members and associates as proxies. His Excellency Rigathi Gachagua and his proxies, especially the two sons, have used the following companies to massively launder money, conceal proceeds of crime, corruption, and benefit from influence peddling. For one, Spiritway Limited, date of incorporation 14th of September 2023, shareholders Dorcas Wanjiko Rigathi, Biz Group Limited, date of incorporation 14th of February 2023, shareholders Kevin Rigathi Gachagua with 50 shares and Keith Ikino Rigathi Limited, PBT date of incorporation 11th of January 2024, shareholders Rigathi Gachagua, Director, Peter Njoroge Regero, number 4686103, Direct shareholder with 1 share. 4, Kuruwitu Properties Limited, PVT, shareholders with Bingo Beach Resort Limited, number C159289, as shareholder with 1,000 shares, and John Y. Malende. Number 5, the Anansi Collective, in March 2021, shareholders Keith Ikino Regarding. 6. Biovet Kenya Limited, date of incorporation 10th of June 2009. Shareholders regarding Gachagua, 200 shares. Dorcas Wandiko regard number CPR stroke 2015/186-154. Date of incorporation 16th of April 2015. Shareholders regarding Gachagua, 50 shares. Dorcas Wandiko regarding 950 shares. 8. Cosmia Venture Limited, number PVT-Q7ULE6Z, date of incorporation 26th of February 2018. Shareholders, Herman Reuter Minor, 200 shares. James Mwangi Kagogo, 50 shares. Kevin, 250 shares. And David Kikemboy Mudhamia, 200 shares. Number 9, Crystal Kenya Limited, number CPR/2009/4898, date of incorporation 12th of June 2009. Shareholders, Kevin Regarding Gachagua, 200 shares. Keith Ikino Regarding, 200 shares. 10. Delta Merchants Limited, number CPR/2009/4874, date of incorporation 9th of June 2009. Shareholders regarding Gachagua, 200 shares. Dorcas Wandiko regarding 200 shares. 11. Vipingo Beach Resort Limited, number C159289. Date of incorporation 5th. Keith Ikino regarding Director. Estate of the deceased James Merito Gachagua, shareholder 10,000 shares. 12. Regarding Gachagua Foundation, number CLG-XXFXRG, date of incorporation 11th of November 2022. Shareholders regarding Gachagua. 13. Dorcas Regarding Foundation, number CLG-G9FV2G, date of incorporation 19th of October 2022. Shareholder Nancy Wamboi Kanyele. 14. Hardland Supplies Limited, number CPR/2009/4881. Date of incorporation, director shareholder with 200 director and shareholder with 200 shares. 15. Karani Farm Limited, number C9 Gachagua, as director shareholder with 700 shares. Dorcas Wandiko Regarding as director and shareholder with 100 shares. 16. Morani Manufacturers Limited, number PVT-8LU7Q8GD, as director and shareholder, 200 shares. Keith Ikino Regarding, director and shareholder, 200 shares. Joshua Karianjaki Waiganjo, director, shareholder, 600 shares. Number CLG-55FD3B, date of incorporation 1st of December 2021. Shareholders, Louisa Jerry Wanjiro, director stroke member. Caroline Jepkemboy Wayaki, director stroke member. Lucy Jogoine Mutegi, director stroke member. Dorcas Kenya Limited, number CPR/2009/4910, date of incorporation 9th of June. Regarding director and shareholder, 200 shares. 19. Rider Furniture Mart Limited, number C141. Regarding Gachagua, director and shareholder, 500 shares. Dorcas Wandiko Regarding is director and shareholder, 500 shares. 20. Royal Pinson Ventures Limited, number PVT-LRU2QZL, date of incorporation 26th of February 2018. Shareholders, Kevin Regarding Gachagua as director and 400 shares, and Peter Kangati Githaiga as as director, shareholder 200 shares. 21, Technical Supplies and Services Limited, Kenya Limited, Delegate Corporation 6th of June years. Sorry, so that again, 21, 2009/4895. Delegate Corporation is 6th of June 2009. Mushiri Wangwo, Director. And 22, Wamunyoro Investments Limited, C number Corporation, 23rd of April 2001. Shareholders, Kevin Regarding Gachagua, Director of Shareholder. Will illustrate, in November 2023, Crystal Kenya Limited, number 9 in the above table, proxy company of His Excellency Regarding Gachagua, purchased Outspan Hotel, situated at Nyeri Municipality Block /1/1669 from Aberdare Safari Hotels for Kenya shillings 535 million. The directors of Crystal, namely Kevin Gachagua and Keith Gachagua, publicly admitted that his family had acquired this property. B. In November 2023, Kevin Gachagua and Lodge, a high-end hotel situated in Nyeri County. Sometime in August 2024, His Excellency Regarding Gachagua publicly admitted that his family had acquired this property. C. His Excellency Regarding Gachagua and his proxies also acquired Olive Gardens Hotel and Queensgate Service Apartments in Nairobi. D. His Excellency Regarding Gachagua acquired the People Beach Resort in Kilifi County. E. His Excellency Regarding Gachagua acquired parcel of 23 in Madera East constituency, where he constructed a helicopter landing facility. F. His Excellency Regarding Gachagua acquired approximately 40 acres of land in Kapuret in Kamburaini in Nyeri County. G. His Excellency Regarding Gachagua acquired 80 acres of land in Meru County. H. His Excellency Regarding Gachagua acquired Dairy Farm. Gachagua used his office of Deputy President to exert influence and connive with unscrupulous Ministry of Lands officials to issue an allotment letter to Wamunyoro Investments Limited, a company that he owns, to acquire 90.925 billion or thereabouts. After that, this company used the fraudulently acquired documents to support a court case at the expense of His Excellency Regarding Gachagua and his proxies were involved in the Kenya shillings 3.7 billion irregular procurement of malaria nets. Regarding Gachagua has used the office of Deputy President to corruptly influence unnecessary and expensive renovation of his official residence. Gachagua has chosen personal comfort, extreme luxury, and pomposity that Gachagua has acquired from proceeds of corruption, influence peddling, and money laundering have been provided and relate to the following. Outspan Hotel, Agwings Project Road. Gachagua has the following proxy companies to trade with the office he holds. A. Agrobrick Investments Limited is a private limited company incorporated in Kenya on 28 May 2017 and a certificate number PVT-RXUP6E. The company deals in building and construction. The company's directors or shareholders are A. Patel and Kishkumar Hasmukbai, a Kenyan national. 48. The company at Syrian Bank opened on 19 February 2022 with the company directors as the account signatories. On 18 October 2022, Bafika Natalal Irani was added as an account signatory and given the full mandate to operate regarding the travel. On 23 January 2023, the company account received a transfer of Kenya shillings 47,015,367 shillings and 75 cents from the Executive Office of the Deputy ODP stroke ADM ADM.1 stroke 57 bracket 70 dated 16 December 2022 from the Office of the Deputy President to Agrobrick Investment Limited for the proposed refurbishment of Deputy President's official residence at Karen. B. Payment from 2 cents was received contract ODP-RT-001 ODP/RT/C, an agreement letter dated 22nd December 2022 between Office of Deputy President and Agrobrick Investment Limited, document as a director of Agrobrick Investment Limited. On 23rd January 2023, the funds were suspiciously transferred through a transfer Vargiani Enterprises Limited. Shockingly, the account had been dormant for around 9 months before it received the payment from the Office of the Deputy President, adding to the reasonable suspicion that it was a special purpose vehicle to siphon funds for His Excellency regarding Gachagua. B. Lusona Events Limited. This is an events management company that was registered on 30th of October 2012 and a certificate number CPR/2012/87037. The company directors are the SBM Bank, which it opened in 2015. The company's directors are account signatories. Ian Jugona Itata was also introduced as an account signatory and is the sole account operator. Point: the account at SBM Bank received a total of 100 million shillings, 262,821.43 from the Office of the Deputy President, characterized by the receipt of multiple above-mentioned proceeds of corruption and money laundering in 8 transactions in a single day as follows. Second of 46,900, 4,806,639 shillings. Thirdly, on 2nd of July 2024, the amount of 4,679,130 shillings. Fourthly, on 2nd of July 2024, the amount of 2,955,450 shillings. Fifth, on 2nd of July 2024, the amount of 3,374,451,912 shillings and 40 cents. Number 7, on 2nd of July 2024, the amount of 3,582,536 shillings and 50 cents. Number 8, 2nd of July 2024, the amount of 3,840,635 shillings and 60 cents. A substantial portion of the Kenya shillings 100,262,821.43 cents was used for luxurious largesse and unnecessary expenditure for carpets, etc., laid down for the Deputy President's functions. Some of the funds were utilized as follows. A. Ian Itata made Kenya shillings 22,800,000 in cash withdrawals. Some of the withdrawals were declared as cash to pay undisclosed beneficiaries. It was suspicious why they preferred cash payments as opposed to bank transfers. B. Kenya shillings 4 million transferred to a law firm. C. Kenya shillings 26,993,350. Investment in fixed term deposits as follows. 1. On 27th of May 2024, Kenya shillings 9,993,350. 2. On 11th July 2024, is reasonably believed to be an act of corruption and money laundering, as most of the money was withdrawn in cash rather than bank transfers, which is a custom for huge payments of these dubious transactions. C. C. St. Nicholas Rehabilitation and Industrial Training Dash AACMO4. It deals with student rehabilitation and St. Nicholas Mugambi Maingi. The company operates an account at Equity Bank, opened on 18th August 2017, with the company director as the sole account signatory. Between 1st March 2024 and 5th June 2024, from the office of the Deputy President, the funds were suspiciously utilized as follows. A. Umarali Motors Limited for Kenya shillings 8.5 million. B. Another Kenya shillings 4 million was suspiciously transferred to Nicholas Maingi's account. A cash trade 2,000 to Umarali Motors Limited on 21st March 2024. The purported payment to Umarali Motors. Further, prior to receipt of the two payments from the office of the Deputy President, the account was transacting in minimal accounts, raising some funds. The payment scheme used typifies money laundering transactions. From the matters outlined in the preceding paragraph, that His Excellency regarding Gachagua, the Deputy President of the Republic of Kenya, using his state office, has committed gross A. Sections 45(1)(a) Corruption and Economic Crimes Act and B. Act. Your Excellency regarding Gachagua, 32 of the Penal Code and Section 29 of the Leadership and Integrity Act. His Excellency regarding Gachagua has continuously misled members of the public through false, malicious, divisive and insightful remarks that are contrary to the provisions of sometime in January 2024. His Excellency regarding Gachagua made a sensational but false accusation that Honorable Justice Esther Maina, Judge of the High Court of Kenya, had engaged in corruption. He publicly said he would present a petition for the removal of the said judge, which he has not done to date, leading to the inevitable conclusion that he knew his allegations were false. On or about 26th of June 2024, His Excellency regarding Gachagua, recklessly and unmindful of the high calling and dignified status of the office of the Deputy President of the Republic, a discreet and tempered leader, especially during moments of national crisis, addressed Kenyans on live television in the issue of national security order, its director and officers. The following is an excerpt of part of the speech. I quote, "The Director General of the National Intelligence Service, Nurdin Haji, was a junior of Director General. Because of his inferiority complex, he chased away all the people who were senior to him when he was in the service, therefore crippling the capacity of that service and making it dysfunctional. 3 directors were chased away and reassigned to desk. Men and women with proven track record of intelligence collection and analysis were removed from the National Intelligence Service, leaving a shell and by the intensity, the anger of the Kenyan people, the agitation of the Kenyan people, the resilience of the Kenyan people." End of quote. Your Excellency regarding Gachagua, how do you plead to count 8, guilty or not guilty?
Not guilty.
Part C, gross misconduct, pursuant to Article 151(b)(3) of the Constitution. Ground 9, gross misconduct, that is public attacks on National Security Intelligence Service and its officers. The phrase gross misconduct generally refers to behavior that is, quote, very unpleasant. Therefore, public attacks against an essential national security order in circumstances that require one to be discreet and tempered constitute gross misconduct. On or around 26th of June 2024, His Excellency regarding Gachagua, the Deputy President of the Republic of Kenya, and mindful of the High Calling Council, both being positions that require a leader to be discreet and tempered, especially during moments of national crisis, addressed Kenya an essential national security organ. His Excellency Gachagua extended the extremely reckless personal attacks to the Director General of the institution. With the unprecedented acts, His Excellency Gachagua acted in a manner that is incompatible with the high calling and dignified status of the office of the Deputy President and member of the Cabinet and the national offense to the extent that A. Kenya, B. They are incompatible with the effective discharge of the potential, given the circumstances prevailing in the country at the time, to significantly diminish public confidence in the viability of the Kenyans. They go against the constitutionally prescribed overvaluance of the office of the Deputy President under Article 148, 5A of the Constitution, which requires the Deputy President to obey, preserve, protect and defend the Constitution and all other laws.
Not guilty.
Round 10, 9, the phrase gross misconduct from the Oxford as the head of state and government under our Constitution and its framework is gross misconduct. As stated in the principal assistant of the President, who shall deputize for the President in the execution of the President's functions. His Excellency Gachagua has persistently undermined, demeaned, and committed insubordination instead of assisting the President in executing the state executive mandate. Instead, he has opted to run a smear campaign against the Presidency for police to perform the functions conferred by the Constitution and any other functions that the President may assign. His Excellency the tea, sugar, and milk sectors, which the President tasked him to oversee. To illustrate, A. His Excellency Gachagua has influenced his family members, allies, associates, and proxies to take control of a local cooperative. Your Excellency Gachagua, how do you plead gross misconduct, that is bullying behavior, that is very unpleasant? Section 34 of the leadership includes repeated offensive behavior that is vindictive, cruel, malicious, or humiliating, and is intended to undermine the person, public officers. To illustrate, A. His Excellency Gachagua bullied Kenya Medical Supplies Agency. Crystal Limited has submitted a fake report with the sole intention of fraudulently acquiring public property. Officers of national security organs whom he subjects to public attacks and humiliation. C. His Excellency Gachagua continually summons procurement officers in ministries and state institutions and instructs them to direct the procurement of goods and services in a particular manner. D. In the Presidency, His Excellency Gachagua identified public ownership and he has severely threatened, intimidated, and harassed them. E. In 2023, His Excellency Gachagua used his position as a Deputy President to intimidate public officers and a contractor to divert materials meant for the construction of the Malindi Road to tarmac a private road to the Pingo Beach Resort. No power as Deputy President solely to implement sectarian, parochial, and personal interests that seek to profit him. Your Excellency, regarding
Duty.
We proceed to respond to the objection that has been raised by counsel for the
For efficiency and expediency, permit me also to bring to the attention one more application in respect to the documents that were served upon the Deputy President of the Senate. The Speaker of the National Assembly did submit the documents that emanated from the National Assembly.
counsel for the Deputy President. Take a seat first. You have your seat.
Preliminary objection that has been raised. Constitution of Kenya at Article 77 is the primary law that then speaks to restrictions on activities of state officers. In particular, Article 77(1) reads, a full-time state officer, Mr. Speaker, sir, that article introduces one critical variable: gainful employment. Mr. Speaker, sir, gainful employment has been defined. Leadership and Integrity Act has defined what would amount to gainful employment. If I may, Mr. Speaker, sir, Section 26(1) reads, the basis shall not participate in any other gainful employment. It then proceeds at subsection 2 to say, in this section, gainful and other form of compensation or remuneration which is inherently incompatible with the responsibilities of the state office or which results in the impairment of the judgment of a state officer in the execution of the functions of the state office or results in a conflict of no assertion that Lion Senior Counsel James Orengo, by representing the party before this House, what evidence has been tendered before this Honorable House to speak to that fact? Mr. Speaker, sir, if I may, in the election petition number 3 of 2013 filed in the High Court in Busia, similar of the Honorable James Orengo Senior Counsel in the proceedings in that matter, the judge handling that case interpreted both Article 77 as read in Section 26 of the Leadership and Integrity Act and had this to say, at paragraph 28, that it had been argued that by representing a party in an election petition, the Honorable Senator would be compromising the This Act is a provision on political neutrality expected of appointed state officers. Honorable Orengo holds an elective position, elected to them. So even if it was to be assumed that, that by representing the third respondent, Honorable Orengo is pursuing a political agenda, that would not be inimical to his office as a member of the Senate. And so, Mr. Speaker, I submit that unless then the Honorable Mr. James Orengo Senior Counsel would have engaged in gainful employment, that objection does not stand any around conflict of interest. What amounts to conflict of interest? In a case determined by a 5-judge bench, a case reported in our laws that is conflict of interest as a situation where one, Mr. Speaker, they are the objector to the participation of Senior Counsel, the Honorable James Orengo. Has there been an indication as to any prejudice that could be occasioned by the participation of by recollection of the Honorable James Orengo before the proceedings in this House would be such that they would fundamentally impair their defense when they get the opportunity to present the case? I'm just asking myself, that has not been said. In any case, Mr. Speaker, sir, if that was to be the case and the fear that has been presented, then as advocates, as counsel, we operate within very clear and defined rules. Those rules are meant to ensure that a party before this House, just like would be a party before any court or any other forum, does not suffer or does not have a compromise with their rights to fair hearing under Article 50. In the absence of any prejudice that has been mentioned before you, referred to by my line friend Mr. Jiru, and with respect, that case stands on two critical points. The first one being, was said to have had the potential of compromising his participation in the Senate proceedings because then he was a senator. He is not left defining that decision and what we have before you. The judge in that specific matter also went on to add that there must also be established a question or a fact of benefit. Again, I reiterate, James Orengo Senior Counsel has in any way benefited by being in this house participating as staff.
Thank you, Counsel, for
no denial that has come from Counsel's defense that Senior Counsel Honorable James Orengo is here on pro bono basis. That evidence has not been brought. That claim has not been denied. He's therefore here as counsel earning a fee, and that is what Section 26.
Senior Counsel, has not been made. Has the evidence of him earning been put on the table?
Mr. Speaker, sir, the only presumption.
No, we're not going to presume facts. We're not.
Mr. Speaker, sir, I am well guided, but may be noted and may go on record that the grounds laid by Section 26, subsection made by Council, insofar as the gainful employment in these proceedings is concerned. Number two, he is here as a governor of the petition number 3 of 2013 is distinguishable from the fact that he's here as a serving governor. And that is what Section 26, subsection 2 speaks to, and that is also equally the provisions of Article 77 of the Constitution. Further to that, Mr. Speaker, sir, the test of prejudice is a creation by Council. It is not the one that adds Section full employment. Unless that one is rebutted, the general presumption, again, Your Lordship and Mr. Speaker, sir, and that is a legal presumption unless it is rebutted. Yes, sir, I leave that to the House to make a determination. Permit me once more to move the House with my last and final application. Sir, these proceedings are in issue. Mr. Speaker, sir, on the 8th of October 2024, this House was served with a resolution from the National Assembly by the Speaker of the National Assembly, vide the letter. The letter appears at page 547 to 548 of volume. An affidavit by one Peterson Jomo Mushira. Our objection, Mr. Speaker, sir, is that that document, that affidavit, did not form part of the documents that were submitted by the Speaker of the National Assembly to the Speaker of the Senate. It's our argument, Mr. Speaker, sir, that this is new evidence. Further to that, Mr. Speaker, sir, we were equally served with a bundle of documents from the National Assembly indicated as responses from various government agencies. Again, Mr. Speaker, sir, this is new evidence submitted to you or to this Honorable House by the Speaker. The prejudice, Mr. Speaker, sir, is that our response was, Mr. Speaker, sir, it's our argument and our application that these documents will prejudice our case in the sense that, Mr. Speaker, sir, they will violate by the National Assembly. It's a tradition of this House, Mr. Speaker, sir, and I refer to the findings of this in a ruling delivered by the Speaker of this House on the 17th of December, which ruling barred the County Assembly of Nairobi from introducing any new evidence. It has been the tradition of this House. Justice will not only be done, but will also seem to be done. We move this House to have these documents expand. Speaker, sir, if these documents will be admitted, we shall suffer prejudice in the sense that we shall have no ability, or we shall have been denied an opportunity to respond to the same. We urge you, Mr. Speaker, sir, to hold that these documents is new evidence, and we rely on Rule 19 of this House rules, noting that Mr. to deal with new evidence as and when the same is brought to the attention of the House. However, the rules guiding the proceedings in the impeachment of a governor or deputy governor provides that new evidence shall not be admitted. Further to that, Mr. Speaker, sir, permit me to bring to your attention the fee of Assembly of Embu. Mr. Speaker, sir, in that case, Justice Odiek, may the Lord rest his soul in peace, proceedings of the impeachment of a president or deputy president are paramateria to the impeachment of a governor. That is to say, they are identical. So what applies in those rules in the impeachment of the governor can equally and should equally apply to these rules. I am most obliged.
Now, counsel for the National Assembly, you have 1.5.
I could respond. Mr. Speaker, sir, I could respond shortly after that.
And our rules.
But never in this kind of occasion. And this is in the book of Exodus 22, verse 22 and 23. And I'm referring because of the language, and from the Living Bible, which is in English is more appropriate. And I read, that is from this King James Version, or fatherless child. And my wrath shall be widows, and your children fatherless. From the Living Bible version, it reads as follows. The language is a little more palatable. You must not oppress, or you must not exploit widows or orphans. If you do so in any way, and they cry to me for and my anger shall flame out against you, and I will kill you with enemy armies. This is the Lord of the Old Testament. Now, I will come back to this matter later. But for now, I want to walk a constitutional journey with the Senate in giving a panoramic view of what our constitutional order is in regard to the office of the President and the Deputy President. Under the old Constitution, we had no provisions like the ones we have in this Constitution. But this Constitution, and I want to persuade the Honorable Senate, that it does not just address fears out of a long struggle and experience of the people of Kenya. And in Kenya, they were addressing rights, and fears. And more importantly, they wanted to ask the Senate to Article 75 of the Constitution, just to draw the attention of the House. 74. Before assuming office, any functions of the state office, a person shall take and subscribe the oath or affirmation of office in the manner and form prescribed by the third schedule or under an act of Parliament. Mr. Speaker, I want to take you to that schedule of office that is administered to the President and the Deputy President, also including members of Parliament. And there's a big distinction. And when it comes to the, and that of the Deputy President, which is found in the third schedule of the Constitution, there are words there that I would plead to the Senate, to the Assembly, and the charges as they've been read out here. Now, the motion, the oath for, or so as follows. I do swear solemnly affirm that I will always truly, and I pause there to emphasize those words that are found in the Constitution, that I will always truly and diligently serve the people of Kenya, that is the Republic of Kenya, and it continues to say as follows, that I will diligently discharge my duties and perform my functions in the said office to the best of my judgment, that I will at all times, when so required, faithfully and truly give my counsel and advice to the President of the Republic of Kenya, and that I will do justice to all without fear. I emphasize the word doing justice to all. Those three words, affirmations for due execution of office, which are found in the third schedule, are not contained in similar words when it comes to the Speaker of the Senate, the Speaker of the National Assembly, the Chief Justice. It only at the Constitution in terms of the election of the President and and the Deputy President. You'll find that, Mr. Speaker, sir, that the President and the Deputy President are elected at constituencies. At constituencies. And in that, at least half the constituencies of the Republic of Kenya. What I'm not trying to say, it has come out, and I say this with utmost respect, that the Deputy President who stands here on trial by the Senate, whereas the Constitution is clear, is elected by the whole country. He's got no area to protect. Under the old Constitution, the President had to be elected from a constituency, a Vice President had to be elected from a constituency as a Member of Parliament. This Constitution has no similar provisions. And now when you come to the functions of the Deputy President, and I think this is extremely important in the kind of relationship that there should be between the President, the need to read for clarity in terms of the Deputy President. And the President in the execution of the President functions, and also he may be assigned duties by the President. The kind of symbiotic relationship that should exist between the President and the Deputy President is underlined in this Constitution. Now, it is uncontestable, and I think this is the issue that I want to deal with in some detail. it is uncontestable from the record that you have, even from the Deputy President, that Kenya is like a company existing of shareholders. That does not sit with the Constitution of the Republic of Kenya. Kenya is not a republic that is established on the basis of shareholding. It's a republic of citizens. So when a Deputy President talks about taking the interest of Watu Mulima, or whatever that would mean, it is not in compliance with his constitutional remit. And the words are there. What he has said in public on this issue is very clear. The second issue is on the question of collective responsibility. You would find out from this constitution that in nearly all the important constitutional bodies established under the constitutions of organs, like the National Security Council. So one would wonder where even the issue of the Director of Intelligence would be discussed in a public forum by the Deputy President when he is the second in command established under the Constitution. So I would want, and I plead with the Senate, look at the utterances of the Deputy President vis-a-vis his role under the Constitution. He has said certain things that I deem to be insightful, that is protected speech. It cannot be protected speech under our Constitution, because under Article 33 of the Constitution, because of what we have undergone as a nation, Article 33, the expressions that extend to propaganda for war, incitement to violence, hate speech, advocacy of hatred, that cannot be protected speech. Now, the other very important point, which I want to put before you, the Deputy President traveled to London, and he went to a hospital in London where his brother was admitted in ICU. When he arrived the next day, he prevailed upon his brother to execute a will. That was on the 17th of February, 2017. Doctors or physicians who are looking after his own brother, after those visits, he walked away. And 7 days later...
Mr. Speaker, I rise to raise an objection.
Can I proceed?
Mr. Speaker, we owe the Deputy President very elementary decency. We owe it to the Deputy President to be basically decent. If this kind of evidence that is not contained in any evidentiary material before the Senate, evidence from the bar supporting. I repeat, Mr. Speaker, we owe the Deputy President the most...
Those amendments, are they contained?
They're contained, they're all here. They are
Refer to the document.
Volume 4. I am not referring, because if I were to refer to every document, we take a lot of time, and I have only 30 minutes. If you look at volume page...
Volume 4 of the National Assembly.
Of the National Assembly.
Pages
114 to... Deputy President is the one who is relying on this will. The death certificate is contained on page 119. And it shows the only person who attended the disease, the brother of the Deputy President at that time, was his daughter. And in the documents on page 128, and this is where Mr. Mardenge and Mr. Njoroge Rigeru, who together with Mr. Rigathi Gachagua were the joint will executors. And they're complaining about the conduct and action of the Deputy President as an executor of the will. And paragraph 8, there, and it says, from bank to other persons as follows. On the date when Nderitu Gachagua died on the 24th, the Deputy President was already withdrawing money. On the day he died, his daughter. And then they say on the 19th of May 2017, again another money was given. You will find it in the documentation. And part of it is what Mr. Njomo was saying.
Proceed, Senior Counsel.
Mr. Speaker, I respect the direction. I'm willing to take a seat right away, but just to point out something. The document you are being referred to is the document you held in abeyance. Because it was given to us later for purposes of our consideration. That's number one. Number two, Mr. Speaker, you remember that my learned colleague talked about how my client traveled to London, how without talking statement speaks to the motion and the grounds in the motion. I beseech this House direct that parties restrict themselves to the motion and the grounds in the motion. The facts you are now being referred to have no basis in the motion and the grounds that those facts are now addressing. I repeat what I said, Mr. Speaker, the ruling is yours. We owe it to the Deputy President and the integrity in these proceedings. I rest.
In fact,
Counsel, I cannot tell you how you're going to make your opening statements. If you're going outside the allegations, that's up to you. The senators are here listening, and they'll be able to make the necessary decision at the end of it. Now, Senior Counsel Orange, there's an averment that you've made that the Deputy President of the Republic of Kenya, on a certain date that you indicated, traveled to London.
yes. The evidence is,
his sick brother.
yes.
He made his brother sign a will. Is that contained anywhere in the document from the National Assembly?
My Lord, Mr. Speaker, if you look at volume 4 from the pages that I indicated, right from page 113, at what time British Airways flight on the 16th and arrived in London on the 17th. The only business that comes out from that document and his documents is that he got a will signed, and there is no further evidence of his activities in London until 20 brother died in London. But all this I'm saying in relation to the allegations that we have against the Deputy President. Mr. Speaker, sir.
Counsel, ordinarily, no objections are raised during the 30 minutes of the opening statement. Ordinarily, I have tried to accommodate, but now we are just in your opening statement. You may choose.
Now what I want to conclude is this. From what I've said, from all our guidance was acquired for a seniority, the outspan and treetops for an amount exceeding 800 million shillings. And we're saying part of that money was not money coming from him, and evidence will show that he was raiding monies that truly belonged to the estate of his late brother to acquire property. If that is not an offense by the deputy president to acquire property, and to drive this point home, the judgment by Justice Minor, which is also part of the record, where she made a determination, and that judgment stands, that the 200 million shillings that was found in an account with a financial institution, and that 200 million shillings, again, the documentation here, if you look at it and we show it in evidence, was the same money that was used to acquire Treetop, were able to use to acquire those properties. So we are saying that the acquisition of these properties came out of criminal conduct, and all the parties Senate. Now, Mr. Speaker, I think that it is critical that we look at the authority of the office of the Deputy President vis-a-vis that of the President, the doctrine of collective responsibility. And I showed why the office of the Deputy President is so important in carrying certain functions, and the incidents have been shown, acts of insubordination, like when he issued a press statement in Mombasa after the president himself, insubordination to the president, who is his boss. And if really one can bring out quickly, is that at every 5 resources here in the Senate, and they abide by certain principles which are contained in Article 203 of the Constitution. This issue about certain areas being preferred because they're shareholders goes against the very spirit of the Constitution. Or the notion that people can be appointed into government on the basis of how they voted, or on the basis that they are shareholders, that is not again borne by the Constitution, because the executive authority that is granted to the executive requires that even in allocation of revenue and appointment of people to serve in the public service must depend on regional balance. So to talk about shareholders, to talk about some people repugnant and in conflict with the provisions in our Constitution. Now, Mr. Speaker, I would want to say this with all the seriousness it deserves. This Constitution is supposed to work. It's supposed to work. And it can only work if state officers are compliant with the provisions of the Constitution.
2 minutes to wind up.
Yeah. Well, if they're compliant with the provisions of the Constitution. The doctrine of collective responsibility and the authority of members of the cabinet spring from the fact that they are all individually and collectively responsible to the president. The government elected to function in a manner that they can deliver services to the people of the Republic. Large picture, the next phase, when you are now going to listen to the evidence and look at the exhibits that we have attached, you will find that a strong case has been made out for the impeachment and removal from office of the Deputy President of the Republic of Kenya. And this Senate should not shy away from undertaking that responsibility. It does not matter that there is a matter that could be taken to DCI or to the AACC. The role of Senate is different to undertake oversight over those who are given responsibility to manage the affairs of the country. And that does not depend on the role of any other agency or body created by the Constitution. Your role is to demonstrate to all people in state offices, whether it is that of impeachment, to demonstrate to the people of Kenya, before you, that person
I'm afraid, Senior Counsel, your time is up.
should suffer the consequences. I thank you. I thank you.
Counsel for the Deputy President. The floor is yours.
Thank you, Mr. Speaker, sir, and thank you, distinguished senators. My name is Elisha Ongoya. I stand here to make the Deputy President's opening statement. Allow me fundamental principles. We are sitting here today as a Senate to discharge a constitutional mandate. And before you are given the cudgels to start discharging any mandate in this Senate, the Constitution demanded that you had to take an oath of office before it was prescribed and why it was framed the way it was framed. The Deputy President reminds you the following terms in your oath of office before you assume the office to discharge the functions of senators. Republic of Kenya, you have to obey, respect, uphold, preserve, protect, and defend the Constitution of Kenya. And you have to faithfully and conscientiously of the Senate. I submit respectfully that the case regarding the proposal to remove the Deputy President from office by impeachment may appear to put the Deputy President on trial, but that is only in the most technical sense of this process. At a more significant level, steadfastness of our Constitution, our constitutional institutions of checks and balances, and actually their capacity to withstand any form of waves and pressures. That is what is truly on trial. His Excellency Rigathi Gachagua beseeches this House to keep in mind that we have a constitution, a constitutional order, and a constitutional democracy. He asks you that at the end of this exercise, let our Constitution to address this House on the defined standard for impeachment of the Deputy President. In a comparable decision by the Supreme Court of Kenya, the case of Honorable Mike Mbuvi Court, it must, however, be stressed for the avoidance of doubt that the power of impeachment, removal, or recall is not one expected to be in constant or frequent exercise. It is only in the face of credible evidence of extraordinary wrongdoing that the conduct of a state officer will be investigated, and even then, only upon sufficient proof of the allegations that the impeachment, removal, or recall. Distinguished senators, as you undertake the assignment now before you. Question number one, we beseech you doing on the part of His Excellency Honorable Rigathi Gachagua before you. Number two, is there sufficient proof of the allegations leveled against His Excellency Rigathi Gachagua? Article 150, Clause 1, Paragraph B, sets out the grounds for removal of a Deputy President from office by impeachment. These grounds are, number one, the drafter's use of the word gross. serious reasons to believe that the Deputy President has committed a crime under national or international law. Again, we emphasize the word serious, then gross misconduct. Surmises, conjecture, street rumors cannot pass muster. This conduct must be the conduct of the person of the Deputy President. It is sufficiently notorious for this court to take judicial notice of when the late Nderitu Gachagua, whose will is now referred to here, died. You are told to investigate the conduct of His Excellency Rigathi Gachagua at a time, or at the time around which his brother, His Excellency Governor Nderitu Gachagua, as he then was, died. It is sufficiently notorious that His Excellency Rigathi Gachagua was not Deputy President of the Republic of Kenya. But that's not enough. You will peruse the motion to be established by these allegations around what may or may not have happened around the time the late Nderitu Gachagua died. You will find absolutely no ground supported by those allegations. Let me disclose here. It is designed to whip your emotions. It has no other purpose. Looking at your oath of office that I've alluded to, there is no room for your emotions to be whipped as the basis of decision making in any act that you engage into in the discharge of your constitutional mandate and responsibilities. What does our Constitution expect of motion to make allegations of any or all the grounds set out in Article 150, Clause 1, Paragraph B of the Constitution? And we begin by submitting it is true that the mover of this motion has written down some allegations in Volume 1 of the documents from the National Assembly. Secondly, the mover of the motion is thereafter expected to supply credible evidence of an extraordinary wrongdoing and sufficient proof of the allegations against the Deputy President. Mr. Speaker, sir, distinguished senators, we submit that is where the mover of this motion ought to start having problems with this House when he's called upon to account. Before you has fallen short of the threshold set by law by multiple miles. When you examine the material before you, you will discover that it will oscillate between the following categories of stages. One, you will have material before you that just plainly false. There will be ridiculous claims here. Then finally, it will end up into embarrassing claims. Allow me, in the case that is before you, at paragraph 74B of the first, has influenced his family members, allies, associates, and proxies to take control of a local corporate society in Madeira, which they are financially hemorrhaging. Number one, documents before you. No name of any ally is supplied in the motion or in any of the documents before you. Is supplied in the motion and in the documents before you. No name of any proxy is supplied in the motion or in any of the not identified. You can imagine, Mr. Speaker, sir, distinguished senators, being called to defend yourself on a claim that you have taken over through your associates a circle that we don't know. Told, now come and defend yourself. I began by saying some of these claims are either ridiculous or embarrassing. Secondly, At paragraph 74A, you will be told that His Excellency has connived with cartels in the tea sector to block the Kenya tea statement. No affidavit, no correspondence from any official of the Kenya Tea Development Agency is before you. No complaint to any agency is before you. It's just a claim which the mover of this motion said before the National Assembly, and surprisingly, to those of us who have some residual faith in our institution. And when we thought that was a joke, we got a joke lifted a notch higher. The National Assembly actually just believed his word for what it is. Not the Kenya Tea Development Agency. Nothing in the 5 affidavits before you. Let's progress, good people. Paragraph 72 of the motion before you states that His Excellency has persistently undermined, demeaned senators. If you accuse somebody of insubordination, the only person who can complain of being insubordinated is the supervisor. It's been sought here to call him to complain. He has been insubordinated. The Deputy President, when he received this motion, wrote to the Secretary to the Cabinet requesting to be supplied by all assignments given to him by the President and any that he has not delivered. To date, as we stand here, we have not received a response to that letter. And yet we shall be told, just believe the mover of this motion, the Member of Parliament for Kibwezi West constituency, that the Deputy President has insubordinated his boss. I began by observing they will move from the false through, and these are the claims before you. At paragraph 64, paragraph A of the impeachment motion, you will be told that His Excellency, the Deputy President, said that he will present a petition for the removal of Justice Esther Maina from your...
15 minutes.
Thank you so much, Mr. Speaker, sir. The claim is that His Excellency publicly complained. Evidence is before you that there is a pending complaint by His Excellency, the Deputy President, before the Judicial Service Commission. So the mover of this motion first has perjured himself in his affidavit by saying that each of these facts are correct, when this fact is false by evidence available. You will find that paragraph 34 of the motion before you, it says that His Excellency falsely threatened to, in fact, he has filed the complaint. Where is the falsehood when there is a pending complaint? That complaint is before you, to the embarrassing. At paragraph 78C, you'll be told that His Excellency routinely summons procurement officers in ministry and state institutions and instructs them to direct procurement of goods and services in a specific manner.